Hello and welcome to your Identities conversations where we talk about interesting issues that range from our social, economic and political issues. There is an issue in our country that has set the country abuzz, the issue of the marriages bill. And to discuss the issue of the marriages bill, I have a lawyer in the house, Advocate Nompilo. Advocate, welcome to the show.
Yeah, thank you.
We want to learn more about what the fuss is about the marriages bill. But I'll read a little bit about the bill and say the marriages bill 2019 repeals and replaces the Customary Marriages Act chapter 5.7 and the Marriages Act chapter 5.11. There will be one act of parliament governing marriages in Zimbabwe, and the act will also update the law in line with the constitution. Civil partnerships, the biggest. Civil partnerships are the equivalent of what would be referred to under the general law as common law marriages. Advocate, there is a lot of buzzing and a lot of worrying issues that have been coming out on my audios explaining, cartoons being drawn, explaining the marriages bill, and the things that are troublesome to the extent that if they are true, they are really a problem for us. But talking to people like yourselves and women's movement and other people, you hear that the bill is very progressive and there's a feeling that unfortunately there is a highlight, there's tending to be a highlight of a few sections that are controversial, but the bill is said to be good. I want to hear from you, what do you think about the bill?
I think the bill is very progressive. It is addressing so many principles from our constitution, which is very important. We need to align our acts to the constitution, issues of equality, issues of rights, promotion of rights of women and children. So I think the bill is very progressive and should be accepted, subject of course to amendment on certain areas.
Amazing. So the learned colleague here, the learned colleague thinks that the bill is good, but requires a bit of working. The good thing is that the bill is still within the working mode. To say whatever your opinion that are true, that are of the understanding of the bill can be incorporated. But can you take us through some of the progressive things that are in the bill that we should look at and say, wow, this is good?
So the key one, firstly, is the issue of child marriages. Section 3 or clause 3 of the bill is very clear that it prohibits child marriages, being the marriages of children or persons that are below the age of 18, which is also in line with our constitution. And so it is very important because you'd find that we had a judgment, a constitutional law judgment, which outlawed child marriages. Yes. So now the law is coming into play to make sure that it also puts that into practice and into law, which is very important because especially in customary law marriages, children were being married off below the age of 18. So now the bill is coming in and saying even if it's a civil marriage or it's a customary law union, it's illegal, it's actually criminal to coerce or force or partake in the marriage of a child. So that is quite progressive.
If it's the child who wants to get married at 18?
Below 18.
Yeah.
So it does not criminalize if two children below the age of 18 get married, their marriage is regarded as voidable. What that means is that that marriage can be cancelled.
Okay.
Yes. But now it becomes very problematic again because if the marriage is cancelled, what if children had already been born from that marriage? If these children already have children of their own, how do we then proceed? How do we take them back into family and into society? The psychosocial support, all those things come into play. So that is also another provision which might need to be worked on.
Right, because why? Because I mean, it's not a marriage subject to children that are within the marriage. It's a marriage because it has to be a marriage if true consenting adults are consenting to get married. But if it's minors who have decided to marry each other, probably customarily, then maybe they have to be assisted to wait until they mature to be able to, despite the fact that they're children, because children can't look after children. Because show me any place where a person below the age of 18 has looked after themselves. even if they are a parent themselves now. So I'm just saying, putting it out there, and I think, as you rightfully say, that maybe a section needs to be addressed that actually addresses a marriage between children.
Yes.
But then, so what other things are coming out that are positive from this bill? And then, so you spoke about equality. I think one of the buzzwords that I'm hearing is you're talking about equality between men and women, equality of marriages. You want to highlight that?
Yes. So the bill is also coming into play and saying that there shall be equality of rights in a marriage between a man and a woman, or parties in a marriage, or partners in a marriage. But I think it needs to go further and explain more even on the property rights of those parties. But it is very progressive to recognize, because even the Constitution also said that there shall be equality of parties in a marriage. And also now, because it is saying all our marriages are supposed to be registered, that is also another way of bringing in the equality of marriages in Zimbabwe. It's another way of eradicating discrimination on the basis of marital status in Zimbabwe. So that is also very progressive.
So what are some of the, so what does registering a marriage do to a partner or to those registering the marriage? What is the benefit?
Okay, the benefit can be seen clearly, especially in unregistered customary law unions, because you find that most of these women always had problems trying to prove in a court of law that they were married customarily to this person. So now, if a marriage is going to be registered, it becomes, or a union is going to be registered, it becomes then progressive in that they won't have problems trying to prove that they were in a union even upon the death of their partner, because unlike other instances where you have to bring two relatives, sometimes even the relatives are the ones who don't like you. So they might not want to testify on your behalf. But now, because that marriage would have been registered, there is already proof that you were in a union with this person, and it becomes very easy for women in different circumstances to prove their existence.
So that's great. That's great knowledge actually you're giving us. It's also important to know that also even some parents, so for instance, if you're a girl and you got married, and you didn't solemnize your marriage, or you didn't have it registered, in the event of you passing, your husband would be denied access to his property sometimes. So it's not just the girl. A lot of women are the ones who have suffered because of this, but also some men have suffered where their property, like, the parents of the daughter or the relatives of the woman actually just grab everything and refuse this man his stuff as well. So I think it is a two-edged sword that addresses equality in marriage for also including men who didn't have access to this. But another thing that I wanted to ask Advocate is around the issue of registering this marriage, right? Which kind of marriages are registered and which types of marriages are not registered?
Okay, so currently we have two marriages that are registered, being the civil marriage in terms of the Marriages Act, Chapter 5.11, and then the customary marriage in terms of Chapter 5.07. Those ones are the ones that are registered or solemnized, as would say in legal terms. And then now, the customary law union is a marriage only in certain circumstances, that is in issues of guardianship and custody of children. So you'd find now that the bill is coming and saying even that union is also going to be registered or solemnized, but that is going to be done by chiefs or traditional leaders. So that brings in another new concept as well, because even accessibility of registration has been very difficult for people in marginal places. So if not, they can access their chiefs for registration. That is also very progressive, although even that area would need also to be properly looked at and amended to watertight it.
So you mentioned that some of the registrations will be the customary marriage is going to be registered at the chiefs, but it was already registered. What is the difference between the proposed registration now and the former registration? Because you've already indicated to us that in this current bill in this current act which is being updated by this bill, customary marriages were being registered. So what is it that is going to change now?
So initially they were going to be registered, or they were being registered by the registrar. Most people know auctions GT.
Yeah.
But
that's
now
for the customary marriage.
Yes, for the customary marriage. But now they are going to be registered by the traditional leaders. So the progressive aspect, as I mentioned, is that accessibility, the issue of accessibility, that now you can just approach your traditional
Yeah.
leader in your area to solemnize that marriage without necessarily having to go to the registrar. But of course, that would also need to be amended, because you'd find that sometimes the issues of jurisdiction would need to be clarified, or jurisdiction of the chiefs, and also even to make sure that there are no illegal or fraudulent misrepresentations of the chiefs as they register these marriages.
But now, you mentioned the issue of, you mentioned how this particular registering of marriages would benefit the equality at law. Is it including the issues of property? Is it going to benefit people around issues of proper distribution upon death or dissolution of a marriage?
Okay, so upon the issue of property, really, we'd find that, I think that, which is another aspect which we could take as progressive as well, Section 40. Because people in unregistered customary law unions were the ones who have been having problems.
No, but even on the registered as well. The registered customary as well as the unregistered. Maybe if you can address.
Okay, so with the customary marriages that are registered, customary law has always been very clear in terms of the Customary Marriages Act. Their property dissolution was being done in terms of the Matrimonial Causes Act. So these ones have always been very covered.
Catered for.
They've been catered for. But the ones in the unions are the ones that have not been catered for. And now that also they've introduced Section 40, I feel that is the one that cushions people in the unions as far as property dissolution is concerned, because now it then comes in and says matrimonial causes is also going to apply upon dissolution. And if the same principles are applied to the union, I think women in unions will then benefit.
Now, we want to move to the most thorny issue, the issue of civil partnerships. What are the civil partnerships? I know that's the one that has sent the whole country abuzz.
Yes, thank you, Nyari, for that. So, civil partnerships, really, in our colloquial terms, we call it kubikamaputu. And I want to mention that here now, that actually in Zimbabwe, about 65% of people in Zimbabwe are kubikamaputu. So
I'm just reflecting right now and saying the people who have, because we know, we're going to talk about it, we know that the cabinet is said to have proposed it to remove the Section 40 that is addressing the legal rights more kubika mapoto. And just to say, the sophisticated few who have access in this country are the ones who are refusing the right to property for people in civil unions. So we want you to explain for us what is a civil union, the reasonable period when we can begin to say this is a civil union, if it's stipulated by the law, and what it is that this law was referring to, and whether what the cabinet has said really holds water as far as procedure is concerned.
Okay, so I'll take it slowly. I'll start off by saying what is a civil partnership. So Section 40 is very clear that a civil partnership is a relationship. These are key terms which might have issues in the court of law to say what exactly is a relationship. But yeah, so the first issue is that there should be a relationship between a man and a woman. So the issue of homosexuality is out. The bill does not chip in civil partnerships that are homosexual. It's saying between a man and a woman, and they should have lived together as a couple. So that's another issue now to say, what exactly does it mean to have been living together? And then you should be above 18, you should not be within the prohibited degrees of affinity or relationship. So kanamuri hama, you cannot get into civil partnerships.
The bill also spells out the issue of incest. You are not supposed to marry your relative, but please continue.
Yes. And then the last one also, which is very key and interesting, is that the people or the couple or the parties should have lived together as a couple on a genuine domestic basis. And I thought that that is the key provision which then churns out or removes some of these small houses or extramarital affairs, because they need to pass through this four-tier or four-pronged approach. And if they cannot show that they were living together as a couple on a genuine domestic basis, then they will not be protected under a civil partnership. So if you're a small house, it does not automatically mean that you are going to be recognized as a civil partner. You need to show these four requirements, that especially that you are living together as a couple on a genuine domestic basis. And maybe to go further, also what it means to be living together on a genuine domestic basis, the bill is providing also that there are circumstances that the court is going to look at. And these circumstances include common residence, they include financial dependence or interdependence, they include whether or not you had a sexual relationship, whether or not there are children involved, whether or not there was any acquisition or use of property. So it's a whole list that the court is going to use to determine whether or not a civil partnership exists. So that really eliminates some of the fears that the society or the Zimbabweans are having as far as the civil partnership is concerned.
But I think one of the biggest concern that people have had has been the issue of how a married person, a woman or a man, can actually get into a civil partnership. And also one of the key things that this bill proposes is that a person within a civil marriage is not allowed to enter into another contract or into another marriage. But now so you're saying with the left you can't enter into a partnership with another person. On the right, you're now saying, oh, but then if you are married, but then you've been seeing this other person, we are saying you've contracted with this person, there's dependability. It's another contract. So you are saying you can't contract, but you're saying contract, and we're going to penalize you for contracting.
So that is the very problematic provision, Section 40, subsection 5. That is the one that has caused all this noise, because it then says that a civil partnership shall exist whether or not either party, or notwithstanding that either party is legally married or is in another civil partnership. But maybe what I would also highlight is maybe firstly to give scenarios, to say there are people who just decide to stay together without being married. They don't pay lobola, they don't register a marriage. They just stay together. Such people need protection. So if we are agreeing that these people need protection, we then need to protect Section 40 up to subsection 4. And then we come to the problematic one now. It is very true that it has caused confusion and it needs to be amended. It needs to be more explicit. But in light also of what Cabinet has said, I might as well comment on it right now and say it qualifies to throwing the water together with the baby.
No.
Because we are saying genuinely there are people who stay together and who need protection. Their property rights need to be protected. But this one now, which is problematic, is the one that we could remove or that we could amend.
When you are saying a married person cannot enter into another contract. But so I think in Zimbabwe we need to not sensationalize issues, because I think there's been huge sensationalization. As you are rightfully saying, I mean, I come from Umosha. Many people are married in civil partnerships. People don't go and pay lobola. Many children have been signed out of such situations. People have built together, they have worked, tilled their land together, and then a woman one day, a man just wakes up and says, "Anshakuda, go back to where you're coming from." And this woman is chucked with nothing. So this is where the law needs to protect these women. So I think there is a call for to be explicit in defining what a civil partnership is. So not necessarily throwing out Section 40, but then explaining that a married person cannot get into a civil partnership. But people who are staying together, who are not married to other people, but they are married, they are staying together. And actually, I think probably it draws me back to where you started, and you said the bill is good, but there's a lot of work. Maybe the work is to go back to the drafters who said their intentions were good, to say we want to protect people who are married but not necessarily married, because this is a form of marriage that's been there, where a non-married person and a non-married person come together. They haven't gone to relatives or whatever, but they built a life together. But then exclude people who are married elsewhere.
Yes, I think because now we are facing a danger of where everyone is going to reject the provision, the whole of it.
Just because they don't want their husbands or wives tied.
Yes.
Because they've got a privilege. So this is an issue of privilege. And yeah, please go ahead.
Really, I think people have approached this provision with so much emotion, and in the end we have lacked the objectivity that we should have approached this provision with. Because you find also that there are people who, nowadays people don't institute divorce. People just separate.
Stay together.
They get married in a civil marriage, then they separate, they don't divorce, and then they move on. They start living with some other people, they start having a life after that separation. Technically and legally, the marriage is still in existence, but practically these people have separated. So I'm thinking that maybe this is the mischief also that the bill was trying to curb. To say, what of those people who are married legally and technically, but the marriage in practical terms is not in existence and the people have moved on. But now, because it's going to open a Pandora of other problems, I thought that it needs to be looked at and revised, and maybe even removed especially the phrase that says whether or not legally married, because even as far as division of property is concerned, how is the property going to be dissolved if this person is in another union and also is in another marriage? If either of them...
How would you bring a property into another marriage when you're still staying with someone else? I agree with you, and I think this is the job that you lawyers and everybody else who cares does. Let's comment as we come to the end. I'm now pressed for time. Let's comment about the position of the cabinet. There is a legal process that this cabinet, there's a legal process that this bill is supposed to go through. And we heard yesterday on ZBC announced breaking news that the cabinet has instructed to Section 40 to be removed.
Yes.
Does the cabinet have that right constitutionally to actually just say, because there's a lot of misunderstanding and sensationalization that's going out there, they are automatically declaring this bill non-existent? Can cabinet do that around the processes that are going on? And if not, at what point can they do that? And also your recommendation to cabinet and to everybody who cares about people in this country.
So firstly, you'd find that our lawmaking process involves the executive at some point, especially in the beginning.
That's the cabinet.
Yes, the ministry is always involved in the drafting of the bill and all. But at the stage that we are at now, this bill has already been gazetted. And from here, we are going to have public hearings. And then from there on, Parliament is going to debate. And from there on, if they approve, it's going to be taken to the President for presidential assent. So here where we are at, Cabinet really does not have the legal authority to remove anything from the bill, because we have since moved from the executive stage. The bill is now in the hands of the legislature and not the executive. So cabinet cannot really, technically and legally, cabinet cannot really remove that provision. But I think also the headline was very proper in saying that they have resolved. It's a resolution. It can be taken to be a proposal that maybe even when Parliament debates
I think we need to the issues of separation of power and the mischief of law and everything. Cabinet, can it resolve at this stage, or can propose, or if their ministers within the cabinet in their own capacities can also contribute to the hearings? What can cabinet resolve at this stage?
So yes, you mentioned very well, Nyali, issues of constitutionalism and rule of law come into play as we think about this, because what is very clear is that also cabinet has succumbed to public opinion and public outcry, which is very okay also, because in lawmaking, good lawmaking involves the public. But at the same time now we are saying, does the cabinet have the authority at this stage? I think the public can only come in their public hearings to put in their opinions, but cabinet on its own cannot really then say remove this provision, because it's now in the hands of the legislature. So my proposal would be, even if we decide to do away with Section 40, let's do away with the provision that is problematic, but not the whole section.
And I think cabinet has got the responsibility to account to the people and to educate the nation into law, to make sure that law protects everyone. We've heard that 65% of relationships in this country are in civil partnerships, and let's not succumb to the few elite who have access to make noise on TV, to make noise on radio, to make noise on social media, but also consider those without access. This was Conversations with Nyari on Identities Conversations. Until next time, do keep well.